Hi there and welcome to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru from the Samfiru Tumarkin law firm here in Toronto. If this is the first time you're viewing our program, well, welcome. Come on in, the water's warm. We got lots to discuss. If you're coming back for maybe a repeat visit, good to have you back again. As you might know already, we discuss workplace rights, employment, the thing that is part of your life that is extremely important. Why? There is tons of misinformation. I would say we are probably neck deep in misinformation that we deal with here, Lior, on the show every week. That's why we do this. That's why it's important. You spend 8 hours a day, 5 days a week, generally, if you're part of the Canadian workforce, right, at your job. So you got to know your rights. You got to know what you're entitled to, and we clear up all the fallacy and the misinformation here on the show each week. We'll get to the Severance Pay Calculator. Reach out anytime you want to find out a radio station where you can catch our radio show and podcast, employmenthourtv.ca. And there's always a number to reach you, Lior, and a member of your team, 1-855-821-5900. But I digress. Lots to get through. We start with a segment we call The Week That Was. What's going on with that, my friend?
What's going on, John, is I've, again, spoken with so many people about their workplace rights. And you started talking about how important workplace rights and people need to know. Most people actually think that they know their workplace rights. Most people think they understand, they know what their rights are. In fact, that's wrong. Most people are wrong because there's so many misconceptions that are out there about workplace rights, about employment law, about severance, about human rights, about constructive dismissal. All those issues, my gosh, that's really why the show is about. That's why we started doing our radio show about 6 years ago, because I saw these misconceptions and I said, I got to do something about it. So that's what we're going to do on this show every week today. Talk about some of those misconceptions, tell you the real truth, things you have to know if you have a job, if you lost your job, if you're concerned about your rights. And we start off every show, John, with a story, something that came across my desk over the past few days. So obviously, if you've been following the news, one of the biggest things recently was the legalization of marijuana. You can't avoid that story, that news. Well, that impacts the workplace in obvious ways. So I had a matter that was easily affected by that very recently. So this company that my client worked for, the client that contacted me, had a policy that you cannot be under the influence of drugs or alcohol at work, which is quite reasonable. They implemented a random drug test. Now, that test may have been illegal, but let's leave that for a second. And in that drug test, this person was found to have had marijuana in his system. So the company said, we have a zero tolerance policy. We are letting you go right away. This person was extremely upset, and when he called me, he said, I did smoke marijuana, but it was about a day and a half ago. It wasn't that morning. It wasn't before work. I was not under the influence. I was fine. And what can they do? Well, the reality is, John, with marijuana right now, testing is very inadequate. There's really no test right now that can come up with whether you're actually under the influence, only if you have marijuana in your system. Well, that's important to know, because just because you have marijuana in your system does not mean you've done something wrong. A company can't let you go for cause because you have marijuana in your system. They can only let you go for cause if you're under the influence. So if there's no reason to think you can't do your job, the fact that you may have marijuana in your system doesn't impact it. So this company did not have cause to let him go. Beyond that, also, a random drug test for most people would be illegal. Unless you're in a very safety-sensitive position, a company doesn't have a right to subject you to a random drug test. So this company did it wrong, and I wanted to bring it up for our viewers, because you may find yourself in a situation where a drug test is demanded. Remember, it may be illegal, but even if something is found in your system, unless it impacts your ability to do the job, unless you're under the influence at work, you cannot be fired for cause for that reason. If that happens, reach out to me.
You know, and since this law came into being, there's been so much talk with employers contacting you about how do I handle this. And I think in the short term, you're just saying treat it like alcohol. Treat it like alcohol. Same rules apply, right?
Absolutely. Just because marijuana is legal does not mean you have to allow it.
Right.
Just like most employers won't allow drinking at work, even though drinking, of course, is legal. So yeah, you treat it like alcohol. If you don't allow alcohol to be consumed during work, you don't have to allow marijuana either. You should expect people not to be under the influence at work. Absolutely. It doesn't matter if it's an office job or if you're operating heavy machinery. People should not be under the influence at work. But just the fact that they may have done or used marijuana in the recent past does not mean that there's a cause to let them go. You have to be careful here, and you have to err on the side of caution.
Again, the website employmenthourtv.ca to catch where you can find our radio show and podcast the show as well, on the radio show, that is. We take a ton of phone calls every week, as we have, sort of, like you said, about 6 years on this show, because people call in, they want to know, they have questions. We cherry pick some good ones, and I know you want to give some feedback on the calls that we have on the radio show, on this show, so we'll do one.
My wife, she lost her job. The company she worked for closed their specific offices where she worked. They're still up and running in other places, but no severance or nothing, and they just kind of laid her off. Is she entitled to severance? She's gone through the Ministry of Labor. The question was whether or not there was a federally registered company, which I believe they are. She was 5 years an office administrator, 41.
Going through the Ministry of Labor.
Yeah, that's a bad situation.
Yeah.
So let's break this down, okay? If you lost your job, like this person's wife, you cannot go through the Ministry of Labor. We've talked about this on past shows. And the reason I say that, it's because the Ministry of Labor can only enforce your minimum entitlements, which is a small portion of what you're actually owed. And by complaining, by going through the Ministry of Labor, you've now prevented yourself. You're now not allowed to pursue your full entitlements, which is a terrible situation. So just because you're asking the Ministry of Labor to get your termination entitlements, you could have lost tens of thousands of dollars. Terrible situation. Now, so right there, I'd want to understand how long his wife has been pursuing it with the Ministry of Labor. You only have 2 weeks to take it out of that system. But beyond that, federally regulated employee, there's again a misconception that federally regulated employees get less severance or different severance than provincially regulated employees. That's false. That's wrong. If you're working for a federally regulated company, it's the same severance as provincially regulated. Why? Because your rights are based on the 3 factors: your age, your position, and the length of your employment. Doesn't matter what industry your company is in. So let's take this person's scenario that we saw the call from, and let's plug that information into severancepaycalculator.com, which, by the way, works for provincially and federally regulated employees.
Part-time, full-time.
Full-time, part-time, young or old, works just the same. And let's see what this person is actually owed. So in a clerical position, 5 years of employment, the age of 41, so they'd be owed right around 6 months of severance. 6 months of severance, that's what this person would be owed. Now, why is that important? Well, 6 months is a long time. If they go through the Ministry of Labor, assuming it's provincially regulated, the most the Ministry of Labor can get them is 4 weeks pay. 4 weeks. That's it. So that's why it's so important not to do that. That's why it's important to go to severancepaycalculator.com. And remember, federal, provincial, the same thing.
That was really the root cause why we started the radio show that many years ago, is because everybody, and you can't blame them, their default position, I lose my job, where do I go? Ministry of Labor. Seems natural, right?
Seems absolutely natural. And people still do this to this day. We've been doing the show for 6 years, and I'm sure in the meantime we've been able to inform and maybe stop people to go to the Ministry of Labor, but still to this day, dozens of people a day, maybe hundreds of people a day, still go to the Ministry of Labor, not knowing that in doing that, they're literally walking away and giving up tens of thousands of dollars that the law says they should have.
Again, employmenthourtv.ca is the source to find a radio show, the podcast of the show as well, and we'll get to, I think we have time for another phone call, at least during this particular segment, so we'll do another one to get your perspective on it, Lior.
My son, he was sent home for 3 days apparently yesterday without pay because he was 2 minutes late coming back from lunch. I was just wondering if they can do that, if they can send you home without pay for 3 days.
So yeah, this is, again, the punishment is not fitting the crime here. You're late, you're getting suspended without pay for 3 days. So let's actually talk about suspension. For non-union employees, non-union, generally there's no right for the employer to suspend without pay, okay? A suspension without pay is not allowed. Suspension with pay is allowed as long as it's the appropriate punishment for the offense.
Right.
They shouldn't be suspending you at all if you were late 5 minutes. That's ridiculous. That's inappropriate. But they can generally suspend with pay. They cannot suspend without pay. A suspension without pay, John, is usually a constructive dismissal. So if your employer suspends you without pay, you may be able to treat that as a constructive dismissal and leave with severance. Now, as a practical matter, if this person was suspended for 3 days and then he's back to work, does he want to treat that as a termination and get severance? Maybe not. He may just say, I'll just continue working.
Yeah.
But I want everyone to understand, especially if you've been put on a longer suspension without pay, you don't have to just sit at home and take it. You may be able to say, no, that's inappropriate. That's illegal. A suspension without pay usually is a constructive dismissal. So if that happens to you, you have that option. You want to reach out to me at that point.
How about those in a scenario, again, non-union, where you've been put on suspension pending an investigation of what you've done? They still can't withhold your pay, isn't that, you're being punished before the jury's out?
So what you're described is, let us punish you in order to
Right.
determine if you should be punished.
Pretty
Now,
much.
if your employer wants to do an investigation and they feel that while we're investigating it doesn't make sense for you to be at work, then they should suspend with pay.
With pay.
They shouldn't suspend without pay, which is a punishment, while they're determining whether you should be punished. That is definitely a constructive dismissal. It also says that they've prejudged the issue. They're investigating when they probably have already concluded that you should be punished, which means it's probably a sham investigation. So that's completely inappropriate.
Email is help@employmentlawyer.ca. The number to reach out, 1-855-821-5900. As I mentioned off the top of the show, when we did our snazzy intro, I said the topic for today, you're owed more severance than you realize. Bunch of talking points. People will not realize this in every case that this is true. Again, the genesis of the whole show is why we do this, to clear up these misconceptions. So can I roll into the first one?
Let's do it.
You may be owed more severance if you've been terminated, quote unquote, for cause.
So before I even talk about termination for cause, let's be very clear, John. Everyone is probably going to be owed more severance than they realize, okay? Because most employers pay a lot less severance. So you may be let go for a reason as mundane as we were restructuring.
Sure.
And the chances of you being offered less severance than what you're owed is great. Most people are offered a lot less than they're owed. So no matter what, you have to find out how much you're owed. You call me, you go to severancepaycalculator.com. But there are scenarios, which we're going to talk about now, where you're pretty much guaranteed to be offered a lot less than what you're owed. And the first one is when you've been terminated, quote unquote, for cause. Let's be very clear. Termination for cause is a situation that allows the employer to let you go without any severance. Unfortunately, most employers get this wrong, and they pull the trigger on a termination for cause before they should. So you may have done something wrong, and then because of that, the company says, you did something wrong, Mr. Scholes, we're going to let you go for cause and not pay you severance. But whatever it is that you did wrong may not be bad enough to rise to the level of cause. The question is not, did you do something wrong? The question is whether it was bad enough. And in most cases, it isn't. So because most terminations for cause are simply false, they're wrong, if you've been let go without severance, you're owed your full severance, you can pretty much guarantee that there's a lot more owing to you. If you've been let go for cause, you really got to reach out to me as soon as possible.
Another one on our list, number 2, the reasons why you're owed more severance than you realize, if the company's been taken over by a new employer.
Absolutely.
Bought out, I guess.
Bought out, sold.
Yep.
So oftentimes, if you lose your job, even if you are offered the job by a new buyer and the company sold, you may be owed severance if you decide not to accept that job. So generally speaking, any sale of a business results in a termination of employment unless you continue working with the buyer.
Okay.
If you continue working with the buyer, then there's no severance. Otherwise, you are owed severance. You may decide not to accept the job with the buyer for your own reasons. You're going to go back to school, you want to spend more time with the family, whatever it is, you're still going to be owed severance. So if that happens to you, if you're not going to continue working with the buyer for whatever reason, call me before you sign anything, before you do anything, because you're absolutely going to be owed severance.
If the new buyer has decided to change my position or move the office or so on and so forth, and I don't agree to it, and I take that as severance, do I get my full severance?
Absolutely, you get your full severance. If the job you're offered by the buyer is a different job in terms of compensation, location, responsibilities, you don't have to accept it because it's a change, and you can absolutely get your full severance. But even if you're not insisting, or even if you're not having your job change, you may be owed your severance. It may not be the full severance, it may be a reduced amount, but you're still going to get severance. So again, if you want to treat your employment as being at an end because the business has been sold, you're going to get severance.
Okay, before the next point, who's pays for it? The buyer or the seller? Who's responsible?
Always, if there's a sale of a business and you have not started working with the buyer, then the seller pays you your severance. If you started working with the buyer and at some point they let you go, that company has to pay you severance. And at that point, John, they have to recognize your full service, your previous service with the previous company. So just because you're working with a new company doesn't mean that your service started from zero. They inherit the previous service.
We are talking about times you are owed more severance than you realize. This one is the one that people always just walk away from, and that's if you're terminated after a short amount of time on the job.
One of the biggest misconceptions when it comes to employment law, we'll talk more about that on the show later today, is that short service means little severance. Okay, that is false. That is not true. Not only is it not true, short service employees are treated even better than long service employees when it comes to severance. So you may have worked for a few months and think, okay, they let me go after a few months. I'm not owed anything. Maybe I'm owed a week's pay, when you could be owed months, several months of pay. So people that are short service and are let go, you can almost guarantee that you've been shortchanged, that you're owed more Don't let that happen to you. Go to severancepaycalculator.com or call me. You could be owed a few months of severance, even if you only worked for a few months.
You may be owed more severance if, number 4, this one again all the time, if you've been working as a contractor. If,
exactly. And that's the big one there. Because if you're not really a contractor, and the law decides if you're a contractor, you don't decide, the company doesn't decide, a contract that you sign doesn't decide.
Right.
If the law decides that you're an employee, you're owed severance. And if the company thinks you're an independent contractor, they're going to let you go, probably not pay you anything. But if the law considers you an employee, you get your full severance. So this is a big discussion which we've had before and we'll have again in the future. But the reality is most people are misclassified. If you're not in business for yourself, if you don't control the job, if you're taking instructions from someone, if you've been working there for a while, you are probably an employee. And if you're let go, you're owed your full severance. So this is a common, extremely common situation where you're going to be owed a lot more than you've been offered.
And paying your own taxes doesn't make it clear either, right?
It doesn't make a difference. You can have your own company. You can be paying your own taxes. None of that actually makes you an independent contractor. Again, substance over form.
Next one on the list is you're owed more severance than you realize if you were hired without signing an employment agreement. This one's good. That's a good thing.
It's a great
contrary to
thing.
most people think, that's actually a good thing.
It is, and you know, I've said that many times. If you're an employee, you would rather not sign an employment agreement. You'd rather start a job on a handshake. Much better than signing an employment agreement, because usually what an employment agreement does is it takes away some of the rights that you have, including the right to full severance. You may have signed an agreement that says, if we ever let you go, employee, we'll only pay you a portion of your severance, your minimum severance. So you don't want to do that. So if you actually have not signed an employment agreement, or if your employment agreement does not limit your entitlements, you're owed a lot of severance. There's nothing limiting it, so I can almost guarantee you in that situation that you're owed more than what you've been offered. And by the way, John, even if you did sign an employment agreement that limits your entitlements, there's probably good odds that it's not enforceable. So the message here is, if you lost your job, and even if you think there's an agreement, I signed this employment agreement, I guess I'm stuck, I guess I can't get my full severance,
right.
Not so fast. That agreement, for various reasons, which I'm not going to get into, may not be enforceable. You got to give me a call. Let me take a look at it, because you may still be owed your full severance.
Severance for long service employees, and of course the severance pay calculator. That's what we are getting to next after we take a short break. Want to reach out? No problem. 1-855-821-5900 is a great number, and help at employmentlawyer.ca as well. Lots more Employment Hour in 30 is on the way. Don't go anywhere.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Employment Hour in 30. Welcome back. John Scholes, Lior Samfiru. Severancepaycalculator.com. That is the first place you go if you've lost your job. Even if you haven't lost your job, you just for interest's sake want to find out what you should be owed, what you would be owed in the scenario that you've lost your job. So we'll get to it. Give me some details on it.
So every single time we're on air here and we talk about the severance pay calculator, there's just a rush of people that use the calculator, and because we see how many hits we have on the website because people find out about it for the first time. I'm so happy about that. That's the point. I want to spread the word about severancepaycalculator.com because I want everyone to get what the law says they should have. That's the reason why we're doing this show. That's the reason why I came up with severancepaycalculator.com. It helps you find out exactly how much you're owed if you lost your job. It's simple. It takes seconds, so there's no excuse not to use it. Once you go to severancepaycalculator.com, you're going to be asked some questions about your job, the length of your employment, your position, and that's it. You don't have to put in the company's name. You don't have to put in your name. It's anonymous, and once you do that, you're going to find out how many months of severance you're owed. It's not a week's pay per year of service. It's not 2 weeks pay per year of service or anything else. It's based on the factors that we've discussed, and for most people, it's a lot more than you realize. So don't ever, ever sign off on that severance offer without checking out severancepaycalculator.com, or as John said, if you're just curious, you want to know how much you could be owed, or maybe you're preparing because you think that there's some bad news coming down, or your relative just lost their job, severancepaycalculator.com.
Absolutely free as well. There's no charge for it, and a contact button at the bottom of the calculator if you want to reach out and contact you, a member of your team. I'm going to run through a scenario for you, a typical one, and I know you want to open this up and comment on it. 63-year-old Jay was working as a senior accountant at a large firm when his position was suddenly eliminated. He spent 28 years at the company, earned $76,000 plus bonus and benefits. He was offered 26 weeks severance pay. What is he really entitled to? 26 weeks?
We took this, I should say, from a real scenario. I changed the names, etc.
Protect the innocent.
Protect the innocent,
right.
But this is a real scenario. And the reason I picked it, it's not because this is a unique scenario. There's nothing special about this scenario you just read. This is one of the most common scenarios, and I get several of these scenarios every single day in my office, 5 days on the weekend, twice on the weekend. So it's very common. So what does this person owe? This person was offered 26 weeks pay, and he may think that's fine. Well, let's actually plug that into severancepaycalculator.com to find out what this person would be owed. So he's a senior accountant, so he's a professional, 28 years of service, 63 years old, making a good salary, $76,000. Was offered 26 weeks pay, John. 24 months pay. As you can see on the screen right now is what he's owed. That's a difference of $114,000. And you may think, oh my God, that's outrageous. Well, it is outrageous, but it's common, and it's the way this works. This scenario is very, very, very run-of-the-mill. You'll see that all the time. People are offered 6 months when it should be 3-4 times that. So don't let that happen to you. If he didn't know about severancepaycalculator.com, if he signed off on that offer, he'd literally be losing $114,000. Terrible.
That's 2-3 times a yearly salary for a lot of employees in this country. It's what he would have missed out on.
Can you imagine? And the worst thing for me is that people sometimes contact me after it's too late when they signed off, and I have to tell them, you just walked away, or unfortunately, you just lost $114,000, and I can't help you. So please don't make me do that. Don't make me explain that to anyone. I don't want to do that. Go to severancepaycalculator.com, and I'll say this again. If you don't want to talk to me because you don't like me, that's okay. Talk to another employment lawyer. Just don't walk away from your entitlements.
EmploymentHourTV.ca. We keep telling you where to find that radio show and the podcast of our radio show. Ton of phone calls on there. We'll play some back. Get your perspective.
If you work for a company for a long time and they want to change the days you're working, is that considered constructive dismissal if you don't want to change your days? In other words, going from Monday to Friday to having to work on Saturdays.
She's heard the radio show before.
She's heard the show,
before.
And she's looking at it exactly the right way. One of the most important terms of your employment, other than your compensation, is the days you work. So your schedule. So your employer doesn't have a right to change that unilaterally, whether it's your hours of work, your days of work, the shifts, the way they're scheduled. They cannot do that. So if you're now are asked to work Saturdays, as an example in this case, when you're not usually working Saturdays, you can say no. And if they insist, that's a constructive dismissal. A constructive dismissal allows you to leave and still get your severance, even though you're the one choosing to leave. So if your employer changes the terms of employment, hours, schedule, compensation, location, responsibilities, you can treat that as a constructive dismissal, get your full severance, and go to a job where that doesn't happen anymore. So remember, it's easy. And by the way, severancepaycalculator.com also works for a constructive dismissal.
Yep. She doesn't like it. That's obvious. What are the pitfalls if she says, okay, I'll be a team player?
Well, so she'll say, okay, I'll work the occasional Saturday, fine, allow you to change the terms. Well, the problem with that is the door was open a crack, she just pushed it wide open, and now the employer can make the changes again because she let them do it that first time. So next time when they say, now we want you to work every Saturday, all of a sudden she may not be able to do anything about it. She may not be able to treat that as a constructive dismissal because initially when she had the opportunity to do that, she accepted it. So once you accept the change, you've arguably given the company the right to do it again and again, and that is a very dangerous precedent to set.
When your request for accommodation results in termination, that's not a good thing, and we'll deal with that after a short break. 1-855-821-5900 and EmploymentHourTV.ca as well. More Employment Hour 30 is on the way. Stick around.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Now, welcome back to Employment Hour in 30. EmploymentHourTV.ca is a great resource. You will find on that webpage where to find our radio show, a market you can listen to, which we've been doing for over 6 years now. It's been a long time. We answer a lot of phone calls and help a lot of people. And we get the phone calls. Sometimes we cherry pick the good ones. We play them back on this show so you can hear them. And Lior, you can give some perspective. We'll get to one more call. I think we have time.
Last year, I was terminated. I was working at a call center. I was there for 7 months. Because of a previous accident that I had, I was having a lot of pain on my neck, and I made a request for medical reasons to accommodate me in certain things. 2 weeks after, I was let go, and I wanted to know if I had some rights here.
Accommodation.
And, like, forget the law for a second. On a human level, you have an injury, and you're asking your employer for help for accommodation, and they let you go. That's wrong, John. They can't do that. And the law recognizes, and that's where the law comes in, and it says it's actually illegal. Once you're asked for accommodation, the employer has to accommodate you, and that's very common with medical disabilities or physical limitations. Your employer has to accommodate even if it's difficult. That may mean giving you modified duties, modified hours, giving you some help, giving you flexibility to work from home, whatever it takes to allow you to do the job. And what they certainly cannot do is to fire you because of that. That's a human rights violation. That's illegal. They cannot do that. So this person right off the bat is probably going to be owed human rights damages because she was fired when she sought accommodation. So that could be significant. And beyond that, she gets severance. Now, we talked in the previous segment about short service employees. So let's actually see how much this person would get as a short service employee. Sure. So she's in a sales role. She is 7 months of service, and she's 53 years old as an example. Well, she'd be getting 3 to 4 months of severance. So you can see that on the screen right now at severancepaycalculator.com, that even after 7 months, you could be owed 3 to 4 months of severance. And that's over and above any human rights damages. So that shows you right there that short service employees are treated well. And also it's a reminder for employers and employees that accommodation is something you have to take seriously.
It's amazing. I would say the vast majority of our viewers are thinking, oh, for 7 months, she probably gets 2 weeks, maybe a week if she's lucky.
If she's lucky. Wrong, false. That's why it's so important to call me, to get advice, to go to severancepaycalculator.com. You can get a few months' pay even if you only work for a few months.
Another great resource to ask questions when we're not doing the show, terminationquestions.com. There's a drop-down menu. There's a good chance your question has been asked in the last several years with in-depth answers, but if not, throw it out there. I know, Lior, either you or a member of your team get to those really quickly and answer those questions. Here's one. My former employee told me that because the company has a small payroll, I'm not entitled to severance. That doesn't sound right, does it?
No, it doesn't. No. It doesn't at all. And there's another misconception that only small companies, only large companies have to pay severance, and that the size of the payroll determines. Now, that may be relevant with respect to your minimum entitlements. It's completely irrelevant with respect to your full entitlement. So bottom line, so we don't confuse anyone, it doesn't matter if you work for a small company or a large company, you get severance full stop. Because remember, it's based on your age, your position, and the length of your employment, not the company's size, okay? So you could work for a two-person operation or in a grocery store or 2 people. You get severance if you lost your job, and it could be significant. So yes, the fact that the company says they don't pay severance doesn't make it so it's illegal. You get severance either way.
So a mom-and-pop operation or a 10,000-employee multinational, severance pay calculator still rules.
Still rules. Works exactly the same. Wow. You get the same amount of severance. Wow. Huge misconception. And a lot of employers get this wrong as well. And unfortunately, the Ministry of Labor perpetuates this misconception. Well, now you know better.
And by the way, there is an employer mode, correct, on the severance pay calculator if you're wondering if you need to let somebody go, correct?
You want to comply with your legal obligations. You want to not put yourself in a wrongful dismissal situation. Yeah. The employers can use that as well. There's additional information there for employers, just as free, just as easy to use, severancepaycalculator.com.
That is the place to go. First and foremost, even before you reach out and contact, severancepaycalculator.com. Use it. It's absolutely free. It takes 30 seconds to go through it. The number also works as well. Phone number 1-855-821-5900 and employmenthourtv.ca. Another wonderful resource. We'll catch you next week. Thanks for stopping by. Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.